fame over to California for the inauguration of the British American Bar Association. And we've done many great programs ever since. Today's program has also been supported by the British American Bar Association. Let me say at the outset, if anybody has any questions during the program, please put them in the Q&A function. And if we have time, we will try to answer them. Now I'm going to introduce our speakers. Firstly, Deborah Herbeck is a partner at Herbeck Kunstler LLC, a New York media and entertainment law firm. She has represented Wikileaks journalists in connection with various book, television, and film contracts. Prior to moving to New York in 1990, she qualified as a barrister in London. And it was thanks to my conversations with Deborah and her enthusiasm for the subject that we initially got the idea for doing today's program. So special thanks to Deborah. Peter J. Lapp is a retired FBI special agent who worked for 22 years investigating and program managing counterintelligence, espionage, and economic espionage matters involving Cuba, Russia, and China. He currently focuses his experience on helping companies with their insider risk programs and is a highly sought-after keynote speaker and media contributor with a variety of news outlets and podcasts, including CNN, Washington Post, Miami Herald, and the International Spy Museum. Pete is currently writing a book about the espionage investigation of Cuban spy Ana Belén Montes, who was arrested for spying for Cuba while working for the Defense Department. The book is entitled Queen of Cuba, The Inside Story on How the Perfect Spy Evaded Detection for 17 Years, is scheduled for release next year. Jennifer Robinson first qualified as a lawyer in Australia in 2006 after attending Oxford University as a Rhodes Scholar. In 2016, she moved to London and became a barrister at Downing Street Chambers, where she specializes in media law, public law, and international law. She advises media organizations, journalists, whistleblowers, and high-profile individuals on all aspects of media law and reputation management. She has also been instructed in human rights-related judicial review cases and has given expert evidence in the UK Parliament and at the United Nations. Jen has appeared before the International Court of Justice and regularly engages with UN special mechanisms. Many of her cases and clients are high-profile and involve novel cross-jurisdictional and comparative law issues. Among her many accolades, she was the UK Attorney General's Pro Bono Hero in 2008 and the International Pro Bono Barrister of the Year in 2019. And just for good measure, she speaks Malay and Indonesian. Ron Chen is a partner in the litigation and corporate investigations and white-collar defense groups at Pillsbury Winthrop Shaw Pittman LLP. Ron previously was an assistant U.S. attorney in the U.S. Attorney's Office in Los Angeles for nearly 22 years, including service as active criminal chief and criminal appeals chief. Ron was the DOJ's representative in Beijing and recently was criminal chief in the U.S. Attorney's Office for the District of Nevada. During his time as an AUSA, Ron handled transnational cases involving fugitive defendants from overseas the United States. With nearly 25 years experience as a federal prosecutor, Ron now focuses on complex China-related litigation and white-collar investigations and representations. Now, we thought it would be helpful if we kicked off today by starting with a brief outline of the relevant facts and the chronology before I hand over to our speakers. Julian Assange is an Australian citizen. He founded Wikileaks in 2006. In 2010, Wikileaks published a series of leaks provided by U.S. Army intelligence analyst Chelsea Manning, and the U.S. government launched a criminal investigation into Wikileaks. In 2010, Sweden issued a European arrest warrant for Mr. Assange over allegations of sexual misconduct. He was in the United Kingdom at the time. Mr. Assange said the allegations were a pretext for his extradition from Sweden to the United States over his role in the publication of secret American documents. After losing his battle against extradition to Sweden, he breached bail and took refuge in the Embassy of Ecuador in London in 2012, and he was then granted asylum by Ecuador on the grounds of political persecution. In January of 2019, Swedish prosecutors dropped their investigation. Shortly afterwards, in April 2019, Mr. Assange's asylum was withdrawn following a series of disputes with the Ecuadorian authorities. The British police were invited into the embassy and he was arrested. He was found guilty of breaching the Bail Act and sentenced to 50 weeks in prison. The United States government then unsealed an indictment against Mr. Assange relating to the leaks provided by Manning. And in May of 2019, it further charged him with violating the Espionage Act of 1917. In early 2021, English District Judge Vanessa Barretsa ruled against the United States' request to extradite Mr. Assange, stating that to do so would be oppressive given concerns over his mental health and the risk of suicide. However, he was denied bail pending an appeal by the United States. And in December of 2021, the High Court in London reversed Judge Barrett's decision on the suicide issue only and ruled that Assange could be extradited to the US to face charges. In June of 2022, the Home Secretary approved the extradition, and that is what prompted Mr. Assange's filing of a formal appeal against Judge Barrett's rejection of the substantive portions of his extradition defense. He's been in prison in London since April of 2019. The current indictment, Judge Barrett's decision, and the High Court's decision are all included in the materials on the link that you should have already received by email. So with that, we'll kick off and hand over to our speakers. Jen is going to kick off the proceedings by explaining to us the current status of the appeal against the Home Secretary's decision and what arguments will be presented on behalf of Mr. Assange. Jen, over to you.
Thank you, Alexander, and thank you very much to the Beverly Hills Bar Association for hosting this important discussion about an unprecedented case. What was not in my bio is that I have been representing Julian Assange since 2010. I'm his longest serving lawyer, and so I've been involved in all aspects of his case, dating back to the original publication of the Cablegate material. But this case is important. I'm so glad we're having this conversation. It is going to set a dangerous precedent for all journalists, not just in the United States, but around the world. Julian Assange faces 175 years in prison for publications for which he's won journalism awards the world over and has been nominated for the Nobel Peace Prize each year since 2010, not least of which out of those publications revealing mass criminality on behalf of the United States. So this is an incredibly important discussion and an important one for the United Kingdom too. We've already seen that the precedent that's being set through this extradition request is one that now is going to set a precedent that any journalist anywhere in the world could face prosecution for publishing truthful information about a foreign power and in the public interest. And so I think for those of you, while this case is about the United States, we shouldn't forget that this case is setting a precedent with respect to governments like Russia and China. And that's why we have free speech groups in the United Kingdom being very concerned that the United Kingdom is no longer a safe place for media workers and journalists. So that's how important this case is. But I only have 5 minutes. So what I propose to do is to cover the current appeal. And I want to first revisit the substance of the publications that relate to the indictment. Then second, to talk about the grounds of appeal. And then third, just to give you a brief overview of next steps. I really like to revisit the substance of the publications because I think getting into the technicalities of the indictment, this gives it more life. And it's important to remember why Julian is sitting in a high security prison, because I think sometimes people forget. Every single one of the 5 national security publications that are the subject of the extradition request exposed US government involvement in crimes. They reveal irrefutable evidence, which I think was one of the most interesting parts of our extradition hearing in 2020. Irrefutable evidence of illegal rendition, torture, black site CIA prisons across Europe, and the aggressive steps taken by the United States to maintain impunity and prevent the prosecution of any American operatives involved in these crimes. I just want to give a brief overview. So if we talk about the diplomatic cables, and that relates to counts 1, 3, 7, 10, 13, and 17. The cables that WikiLeaks released and revealed with media partners showed evidence of US government involvement in targeted and extrajudicial assassinations in Afghanistan and Pakistan, including targeting journalists for death. They showed the deliberate killing of civilians, attempts to improperly influence judicial proceedings and subvert prosecutions of US personnel, US involvement in the conflict in Yemen, training of death squads in Bangladesh, and corruption in US-backed dictatorships. I think one of the most important parts of the evidence in the extradition trial was the way in which the WikiLeaks material was used in the European Court of Human Rights in the case of El Masri in Macedonia, which was a case about extraordinary rendition. And so I think it's really important to remember that the diplomatic cables were and the material release have been incredibly important from a journalistic point of view, but also from a human rights accountability point of view. The next category of material that was published by WikiLeaks relates to the rules of engagement, and that's counts 1, 4, 8, 11, and 14, which you'll have reference to in the indictment that you have. These counts relate to the release of the 2006 to 2008 version of the US-Iraq rules of engagement. And these were released alongside with the infamous collateral murder video. Many of you, I hope, will remember that. And if you haven't, I encourage you to watch it. It was part of the collateral murder release that WikiLeaks published, which was a video showing the US shooting down civilians, including Reuters journalists. The reason why the publication of those rules of engagement were important and why WikiLeaks published them is because the US government was maintaining that the killing of those civilians and the journalists in that context in Iraq complied with the US's rules of engagement. What the WikiLeaks publication showed was that that was a lie and that it was very likely a war crime. So the importance of those publications are very clear. The next category of documents relates to the Guantanamo detainee assessment briefs, and that's related to counts 1, 6, 9, 12, and 18. And I think these are important because it showed that detainees were subject to prior rendition and detention at black sites, but also showed how flimsy the evidence was that was being used to hold these men in Guantanamo Bay. And I think the WikiLeaks disclosures, well, not I think, we had expert evidence and evidence from those working on these issues in the extradition trial to show how important these disclosures were for accountability on Guantanamo. And indeed, Biden has reversed the policy and wants to shut Guantanamo as a result. And the last category of documents which are the subject of the indictment are the Iraq and Afghan war diaries. Then that's counts 1, 15, and 16. These revealed war crimes, including the kill and capture lists, the killing of civilians, and the role of Pakistan intelligence in arming and training terrorist groups. The Iraq material covers a 6-year period exposing cases of torture, abuse of Iraqi prisoners by Iraqi police and soldiers, and the deaths of more than 100,000 people in Iraq, and more deaths of civilians than the US government was reporting. So it's clear that this material is material that was published in the public interest. And for that, Julian has won, and Assange and WikiLeaks have won journalism awards the world over. So looking at the disclosures, then thinking about the grounds of appeal, I'm only going to address the grounds of appeal that arise from the judgment of the magistrate at the beginning of 2020. There are further grounds of appeal, but they've not yet been made public, so I'm not going to address those. Looking at the grounds, the first ground of appeal relates to Section 81 of the Extradition Act, and we are arguing that the district judge was wrong in her conclusion that we say that the extradition should be barred on the grounds that the request is for the purposes of prosecuting and punishing Julian Assange for his political opinions. And under that ground, we're raising evidence of the history of WikiLeaks, its mission, Julian's political opinions and political activism around transparency and accountability, and his efforts to reveal US state criminality, and through transparency and accountability, change US government policy. The next ground of appeal, the next group of grounds of appeal, grounds 2 to 6, relate what I would call the human rights grounds. We say that extradition should be barred on the ground that it would result in a violation of Julian Assange's human rights. And we raise a number of points under this sort of group of heads of challenge under the Extradition Act. The first relates to the unprecedented nature of the prosecution. And I'm sure we'll have much more discussion about that shortly. But the fact that this is the first time in history that a publisher is being prosecuted under the Espionage Act. And we say that it was not foreseeable, given 100 years of practice of not prosecuting publishers for publishing material in the public interest and classified material in the public interest, that this was not clearly not foreseeable. And the law is not settled. So it's not clear how the law will play out in the United States. And we say that that's a breach of his Article 7 rights under the European Convention on Human Rights. The next ground relates to Article 10. When we say Article 10, your First Amendment, Article 10 is the right to freedom of speech under the European Convention. And we say that this prosecution will violate Julian's rights under his free speech. This is a disproportionate prosecution that is aimed at prosecuting him for publishing public interest material. And we also raise the disproportionate nature of the sentence. So if you were to look at official secrets prosecutions, for example, in the United Kingdom, the sanctions wouldn't go beyond 2 years in prison. Julian faces 175 years in prison for the publications for which he's being sought in the United States. And we say that that's a grave violation of his Article 10 rights. The next group, and I should say considered with that, is the fact that the United States government has said on the record that they will seek to make arguments in the case that Julian will not even benefit from First Amendment protections if he's extradited to the United States as a fellow Australian citizen. Apparently, we're not entitled to your constitutional rights. We're also going to be raising questions about fair trial, and what we say is the fact that Julian will not get a fair trial in the United States. The next group of grounds relates to abusive process, and we raise a number of different types of abusive process arguments. The first relates to the nature of the UK-US Extradition Treaty. Julian is, of course, being sought for extradition under the Espionage Act, which is the most typical of political offences under international law. And the treaty between the UK and the US actually prohibits extradition on the basis for the purposes of prosecution for a political offence. Now, what's happened is that in the United Kingdom, the domestic statute, the Extradition Act, does not preclude prosecution or extradition for political offences. And we say it's abusive process for the United States to seek his extradition when the extradition treaty between the two states, which forms the very basis of any request, does not allow for it. And on that basis, the case should be thrown out. We also raise questions about the way in which the United States has put the indictment and the facts that have been put forward by the US, we say are misleading and on a proper reading of the facts that Julian should not be extradited. And then finally, we raise a bunch of arguments about the abusive nature of the process related to the nature of the process, it's the prosecution, the political nature of it, the abusive process inherent in the process so far. So the spying on us as lawyers, spying on Julian Assange and his medical professionals, the seizure of legally privileged material, the sorts of things that, as Daniel Ellsberg said in his evidence before the extradition, in the extradition hearing in London, that the kind of abusive process that was enough to have his entire case thrown out with prejudice under the Nixon administration. That's just a very quick run over. I've already gone over my 5 minutes, but just a quick word on next steps. We've now filed our cross appeal, which the US has time to respond to it, and then it will go before a judge to determine whether we'll have permission to appeal. It's not, you don't get, it's not an appeal as of right, we have to seek permission. That will be heard before a single judge on the papers, and then there'll be a longer appeal process depending on how that plays out. So it will end up before the High Court, some semblance of permission, depending on the grounds we get permission on. And that process between now and any of our ultimate final appeals could take any number of years, 2 to 3 years, in which time Julian remains in prison where he continues to be refused bail at the request of the United States government. So I am happy to answer more questions, but I think I've already gone over time, so I'll leave it there.
Jen, thank you very much indeed. I have one question from the audience here. From Robert Alschuler. Have the US crimes Jennifer is describing in the indictment ever been acknowledged or addressed by any agency of the US government?
Well, there's a very long list of them. And I think US lawyers on the line would be better placed to acknowledge that. But we have been, as I said, the material has been used in human rights cases around the world. Experts, NGOs, whether the United States government has acknowledged it or not is a separate question. But we had evidence in the case from various lawyers who have worked on cases before the US courts, including on Guantanamo Bay and others. We do know that some of these cases are being sought for prosecution and investigated by the ICC prosecutor. So, I mean, it's a big question. I can take each crime on its own, but I would say that there is ample documented evidence by third-party institutions, by the United Nations, that these documents have revealed crimes.
Reading through the indictment, the allegations against Julian are not simply that he or WikiLeaks published the information they received from Chelsea Manning, but it was more than that. It goes to the fact that they solicited leaks by putting out most wanted leaks lists, and they communicated and worked with Manning to decide what information they wanted him to provide, and they even went so far as to try to help him crack some passwords. Does this case go beyond the role of a purely sort of passive publisher of information and address these more active examples that the US alleges to be, part of an espionage activities? Is that part of what the case is about?
That is part of the United States case, but I think it's very important to talk about the acts that WikiLeaks engaged in or didn't engage in. And I want to make very clear, there is no evidence of any hacking in this case, and that is not the US government's case. So I want to make that very clear. But we had evidence in the extradition case that journalists engage with sources inside of the government all the time to discuss the nature of the material that might be available, what material they have, what material they might be willing to give, and why that material is important. So WikiLeaks publishing a list of information that they might be interested in, or speaking to a source, having any kind of communications with the source about what kind of material they might release, is the kind of activity that national security journalists engage in all day, every day. And we had evidence from Der Spiegel journalists, from journalists who have worked with, not Der Spiegel, but various journalists from around the world who worked with WikiLeaks on the diplomatic cables, saying that this is the kind of activity that they engage in all day, every day. And I think as lawyers who defend journalists and who work with journalists who are preparing their stories and who engage in journalistic activity, the description of conduct by WikiLeaks is no different. And in fact, Alan Rusbridger, the editor of the Guardian, said that Julian did what all good journalists ought to be doing, and that's what he's being criminalized for. So I think it's really important that we look beyond some of the broader allegations and look at what actually happened and think about what the criminalization of this means. This is why you have the New York Times and the Washington Post saying that this is criminalizing public interest journalism practices that we've been engaging in for decades. So I think it's important to think about it in that context and what it means for other journalists.
Any of the panel have a question for Jen?
I guess if you don't mind, I'd like to weigh in, and I suppose that if Mr. Assange does get extradited to the US and there is a trial, there will likely be a motion from the government to limit or perhaps even preclude evidence regarding abuses by the United States on the theory that the issue is really Mr. Assange's access and what he did with the information he received. And I suppose one thing that they would argue is that, it's one thing to focus on these things involving what happened at Guantanamo, what happened in Iraq, what happened in Afghanistan. But if taken to its logical conclusion, what the defense's argument really is that all information in the possession of the government, whether it relates to something that is in the interest of the United States, whether it results in something that the United States requires for its defense, or whether it's something, as in this case, perhaps shows an abuse on the part of the United States, is something that should be protected so long as whoever's in charge designates it properly. I mean, I assume you anticipate that that's something that will come up.
I'm sure our US team has anticipated that, and indeed there's no public interest defense under the Espionage Act. So a discussion about the public interest in the disclosures in the United States trial, I think, may well be limited. And I think, in a way, that's a very narrow way of looking at the case. It's a very lawyerly way of looking at the case. And I think it's important that we look at that. You can't look at this in isolation. And to say that all material, however classified, should never be released means the Pentagon Papers would never have been released. It means so much important information in the public interest. Indeed, the classified information that you read in your US newspapers all day, every day, published by mainstream media organizations about what's happening in the world. So to suggest that any publication of classified information should be criminalized is frankly, in my view, wrong, and would mean that every newspaper in the country or close to would be guilty of a crime and should also be in prison.
So it's an all or nothing.
It's not an all or nothing. There's protected activity by journalists, protected by the First Amendment, to be able to publish information in the public interest, including classified information.
I think we're going to pursue this balance of these two competing, rights. The government, presumably, we all agree, has a right to protect some aspects of its national secrets. The journalists have a right to publish items that they believe are in the public interest. So this is a sort of balancing act that I think we'll explore more during this program. I think at this stage, if you don't mind, Jen, I want to hand over to Pete. And Pete, I'd like you to please explain to everybody from point of view of your experience in espionage and counter-espionage as to really how damaging was this information that WikiLeaks published, and to what extent did it actually harm the national interests?
So let me start off by saying I agree with Jen that this is unprecedented. And the government sometimes takes on unprecedented cases. We're seeing that live in Mar-a-Lago in real time. That's an unprecedented investigation and potential prosecution. And just because it's hard, never been done, doesn't mean it won't be tried. I don't agree with Jen that espionage is a political crime. Robert Hanssen gave classified information to the Russians that killed people. Ana Montes gave classified information to the Cuban intelligence service. And there is not a political espionage-related investigation, has nothing to do with politics in Mar-a-Lago, period. I think if we're going to talk about Assange's titles, professional titles, in addition to journalist, we have to also use a word that he's used, and that's hacker. He's a self-described hacker in WikiLeaks, and I quote them, "Think globally, hack locally." So we have to be transparent and honest and say that not just a journalist, but also a hacker. Big difference between New York Times, in my opinion, and WikiLeaks. I don't believe the New York Times would, and certainly I see no evidence they did, try to work with any source to gain access to any type of computer system. And I think that's a fine line where we distinguish between a WikiLeaks and a New York Times. I also know for a fact that the New York Times went to great lengths to redact the names of human sources that were cooperating with the US government, and WikiLeaks did not. Admittedly, Chelsea Manning did 7 years in a military prison, which is not an insignificant amount of time. I don't find any evidence, and I doubt that former President Obama would have commuted her sentence if there was any evidence of a human source being killed as a result of the WikiLeaks disclosure. However, I do believe, and the DoD damage assessment agrees with that, and also says that there certainly was a potential that there was harm to intelligence sources, informants, and the Afghan population. When you develop a source, when you recruit a source, and I'm not going to embellish my own resume and say I've recruited sources overseas in a war zone. That's not the case. But a key to recruiting a source, whether they're a source of a journalist or the source of an FBI agent or CIA case officer, is trust. And in this case, we've got the names of individuals that were cooperating with the US government. I'll read from the government's indictment real quick. A classified document in 2007 threat report contained details of a planned anti-coalition attack at a specific location in Afghanistan. A local human source reported the planned attack, and that individual's name was published vis-a-vis WikiLeaks. We can't prove, and we'll never be able to prove, whether that individual died as a result of the WikiLeaks disclosure. I can assure you, I don't think it's hyperbole to say that the disclosure had a chilling effect on the US government's ability to recruit other sources, perhaps even retain this source that's here. I would imagine this source, once their name was out there, would have stopped cooperating with the US government. And I don't think it's a stretch to say that that chilling effect caused other folks that perhaps had pre-advanced knowledge of another planned attack, probably didn't speak up to the US government for fear of being disclosed, and lives could have been killed as a result of that. If you don't believe me, and if you don't believe the US government, believe the New York Times, who published an article in July of 2010. Taliban studied WikiLeaks to hunt for informants. There was a Taliban official who called the New York Times and said, if they are spies, then we know how to punish them. That sent a warning message to any future human beings that may cooperate on behalf of the United States government to help prevent the loss of lives. The Taliban put them on notice saying, we're watching, we're looking, and we know how to deal with you and punish you all. I want to credit the New York Times for, of course, they were a part of publishing information as a result of WikiLeaks. They went to great lengths to redact the names of any people that were named in the disclosure from Chelsea Manning to Assange and WikiLeaks. They went to great lengths to protect that. And they did it for some, I think, altruistic and patriotic reasons. And this moral code, if you will, of trying to protect people that were putting themselves in harm's way by providing intelligence to the US government for the purpose of saving lives, not just the lives of US military people, but the lives of coalition military folks that were cooperating, the lives of Afghanistani military folks, and civilian Afghanistani lives. They were working very hard to protect those identities, and I think the New York Times deserves great credit for that. And that's a big distinction between the New York Times and WikiLeaks, in my opinion. Oh, last point, real quick. Osama bin Laden. The raid on May 2nd, 2011 in Abbottabad, after bin Laden was killed, obviously an extensive search of his home there. The US government found quite a bit of information from WikiLeaks, from the disclosure in the home of Osama bin Laden, information that had been made public. I got to be honest with you, if the Taliban and Osama bin Laden, two of the United States' greatest enemies ever, if they're reading your stuff, you're probably on the wrong side of both the legal and the moral side of this discussion.
Jen, Deborah, would you like to respond?
I would love to. Deb, do you want to go first?
Oh, I don't know where to start. I mean, first of all, I guess the most important point that needs to be corrected here is the idea that if any credit is due in connection with going to efforts to redact the names of human resources in the swath of materials that were released by Chelsea Manning, it is WikiLeaks, it is Julian Assange. He took copious measures to ensure that every name was redacted, to the point that The Guardian was getting annoyed because it was taking too long to publish the materials, because WikiLeaks was so wed to the idea of not publishing any names. This is the problem, is that there is so much misinformation out there. If you actually research why those names ended up becoming available to the public, it was a Guardian reporter who released information that enabled the unredacted files to be decrypted. It is completely wrong to give the New York Times this credit. It is WikiLeaks and Julian Assange who deserve that credit. You can take the next point, Jen. I think we could go on all day.
Well, I think the point about redactions is an important one, and the redactions were done not just by the New York Times, by every media partner that WikiLeaks partnered with. First, WikiLeaks protected the material by encrypting it and requiring every media organization to use encryption technologies that they weren't previously using. WikiLeaks brought that to media organizations and improved security procedures. Then the redaction was done globally by each media partner, and WikiLeaks then published the material redacted as the newspaper articles were going live. I know because I negotiated it. The only reason the unredacted material was published, and published by a US citizen from the United States, was because of a security breach by The Guardian. So this is all in evidence in court. And so to suggest that WikiLeaks dumped the material irresponsibly is frankly wrong. And I'm pleased to be able to correct the record. The second point that you made was that about WikiLeaks being, Julian being a hacker. He was a hacker in the past, but that has got nothing to do with this indictment or the conduct of WikiLeaks. WikiLeaks receives information. In no way did they access computer systems, which is, I believe, what you said, Pete. The difference between the New York Times and Julian is that he accessed computer systems. He did not access any computer system for the purposes of these publications. It was purely receiving information. Another point that you raised was around espionage. My point was one about law. Under international law, espionage is defined as a political offence, the most political offence of all, which is historically under international law precluded from extradition under historically most extradition treaties, and certainly the US-UK treaty. So it wasn't a comment about the politics of a case, it was a comment about the definition of the defence. You also made a couple of points about human sources being killed. I want to make clear that on the US government's own evidence before the extradition court in the United Kingdom, in a signed affidavit from the prosecutor, there is no evidence that anyone was killed as a result of these publications. And so I think it's really important that we take that as the starting point. That's the US government's own evidence.
No, 100%. I totally agree. And I don't think I said that. I said the potential for them to have been killed is there, or the potential loss of lives as a result of sources not wanting to cooperate anymore.
Sure. Now I have one last point, but I will let everybody move on. But Pete, I appreciate that. And I do think that it's important to say that what the New York Times does and what WikiLeaks does, the definitions around journalism and who does what. Sorry, the last point was about the publication of the fact that the Taliban were reading WikiLeaks materials. The Taliban and Osama bin Laden also read the New York Times and every other media organization that publishes classified information in the context of their news stories. So to make that distinction, I think, is wrong, and also one that's dangerous. So if you're saying, if your point is, and this was the basis of the aiding the enemy charge that was ultimately not pursued against Chelsea Manning, and I remember sitting in court in the pretrial hearing when this charge was read, saying, well, if you publish anything on the internet, publish information on the internet, and a terrorist somewhere happens to read it, you're aiding the enemy. It's a terrifying argument when you think about it from a free speech point of view. So to suggest that somehow we're on the wrong side of history because Osama bin Laden was looking at WikiLeaks material, Osama bin Laden was also reading the classified information being published by every other media organization around the world. So I think it's a distinction that I think takes you down a pretty dangerous path.
Pete, a quick response before we go on to Deborah.
So just in terms of the hacking, I believe, the government alleges in their indictment that he conspired to help. I don't know that he actually got to that point. He certainly, the government seems to allege that he was conspired to assist with that, and that to me, I don't think it's an irrelevant fact. Whether he accomplished that or whether Manning needed that help, I don't actually know, to be honest with you, but it does seem to be a distinction. I don't think Bill Keller would help or offer to help hack with a source. I do think that's not I think that's a reasonable argument. Again,
there's no evidence of any hacking or material provision to assist in any hack. And indeed, if you talk to Alan Rusbridger, the editor of The Guardian, who was the media partner in the United Kingdom, he said that what the evidence shows is actually all Julian was doing was talking, the allegation is that he was assisting a source to protect their identity, and journalists offer that advice. And in fact, your ethical obligations as a journalist is to assist your sources in protecting their identity. So I really think it's looking beyond the government's allegations. I mean, the government published a press release saying Julian Assange sought for extradition for hacking. that was the the headline of their presser, which is completely disconnected from the reality of the facts. So I think it's really important to interrogate that a little bit more closely.
There's a big dispute of facts over those issues, and I think that'll end up being important. Pete, thank you. Deborah, I wonder if we could move on to you now, please, and to perhaps rebut a little bit in addition to what you've already done, this idea that the files and the documents that WikiLeaks published were so damaging to the US national interest, and to what extent their publication is justified by the public's right to know if their government has committed crimes. I wonder if you could speak to that for a few minutes.
Yes, and I just want to make a couple quick points before I forget, just to sort of wrap up the discussion that was just had. When you, Alexandra, say there's a dispute as to the facts, there really isn't a huge dispute as to the facts in the indictment in the court. The dispute is in the media. The dispute is because people, with all due respect, like Peter, hear things that and read things that aren't true and assume that they're true. There was such a huge character assassination that went on here, and there has been a deliberate misinformation campaign in connection with what's going on in this case, to blind ourselves, to blind the public from the outrage that's really going on here. It's a very serious matter, and this is what we do. This is what states do, is that they demonize people and make them a pariah, so that you can say, okay, he's a terrible person. I don't really care. It's fine I hope he rots in jail. And then we're not really paying attention to the fact that that's setting a precedent for the rest of us. Take the death penalty. Yes, there's some really bad people that you might argue, who cares if they get killed? 99.9% of the people who suffer from the death penalty do not fall into that category. So we make terrible laws by demonizing human beings, and this is an example of that, and we have to see it in that manner. And another good point you made, Alexander, was how the key here is the balancing of national security interests versus press freedom. The important thing to remember when we're criticizing the press for putting informants' lives at stake, it's not really the job of the press to be protecting the military. It's not really the job of the press to be aiding the CIA in its recruitment activities and making sure that lots and lots of people want to sign up. It's more the job of the press to hold governments accountable. It's the job of the press to dig, to bring transparency, to shine a light on what's really going on, so that the public in a democratic society can know who they're voting for and know what the people that they're voting for are doing with their tax dollars. It's awful when there's collateral damage, but the collateral damage that happens from dreadful wars is really what people like Julian Assange are worried about. Julian Assange at core is a peace activist. He's an anti-war advocate, and that has turned him into persona non grata and a dissident, and that is what this is all about. But my main purpose of being here is to get into why, as American lawyers, we should care about Julian Assange. And I truly believe that it's because this is one of the most important cases of our lifetimes. Let me start with a quote from ACLU Director Ben Weisner to help encapsulate the issues here. He wrote, "For the first time in this history of our country, the government has brought criminal charges against a publisher for the publication of truthful information. This is a direct assault on the First Amendment. It establishes a dangerous precedent that can be used to target all news organizations that hold the government accountable by publishing its secrets." This is what this case is about. Press freedom is in the very First Amendment of the US Constitution. In a democracy, the press acts as a fundamental check on government overreach. At stake is the public's right to know what the US government is doing in our name. Without transparency, without accountability, we have no meaningful democracy. Jen very helpfully got into the substance of the leaks and reporting that has placed Julian Assange in maximum security prison now for 3.5 years. Prior to that, for 7 years in the sanctuary of the Ecuadorian embassy in London. Essentially, he's lost his freedom for longer than the actual leaker, Chelsea Manning, was actually behind bars. But in any event, the 18 charges in the indictment all relate to WikiLeaks' publication in 2010 and 2011 of the evidence of the war crimes committed by the US and UK governments. The collateral murder video and the Afghan war diaries were very, very important in shining a light on the war crimes being perpetrated in our name. Chelsea Manning was disgusted by what she witnessed the government doing in Iraq and Afghanistan. She thought that when the public found out about what was going on, it would make a difference. And it did make a difference. It made an enormous difference. US and UK war crimes were exposed, and public support for wars in the Middle East began to wane. And indeed, the US did finally withdraw from Afghanistan. The exposure of the illegal activities at Guantanamo Bay have already led to a commitment to close that facility. Now, the press generally enjoys a public interest defense in connection with its publications of public secrets. This is fundamental, as I've said. All that needs to be shown is that the publication of a government secret is in the public interest. Interestingly and inappropriately, Julian Assange is being prosecuted under the Espionage Act, where there is no public interest defense. This is why they're using this completely inappropriate statute. The Espionage Act was enacted over 100 years ago during the First World War to deal with spies, to deal with saboteurs. Julian Assange is an Australian reporter. He wasn't spying on the US government, nor was Chelsea Manning for that matter. Chelsea was a whistleblower. Reporting and publishing acts of the government, even embarrassing acts, or war crimes, is not spying. It's not treason. It's called investigative journalism. Utilizing the Espionage Act in this matter criminalizes investigative journalism. Journalists take steps to protect the confidentiality of their sources every day. It's called journalistic ethics. Journalists solicit and receive classified information every day. It's called news gathering. Politicians and other insiders deliberately leak classified information every day. If this activity is criminalized, the window into government activities is going to be closed shut. And you cannot get away from that by saying he's a hacker. He's not being prosecuted for hacking. The one out of the 18 charges in the indictment even alleges any kind of electronic crime. And that, as Jen rightly pointed out, is in connection with an allegation that he helped his source, or tried to help his source. As I understand it, it wasn't successful, but he's alleged to have tried to help his source protect her identity. That is something that journalists do all the time. As a media lawyer, as an American concerned with press freedom, I'm extremely concerned about this weaponizing of the Espionage Act to silence the routine practices of investigative journalists in the digital age. This case.
Thank you, Deb, very much indeed. I think that's a very good segue into Ron. Your thoughts, please, on as a former federal prosecutor, as to whether or not Julian will receive a fair trial, as to the issues that will be pursued by the authorities if he is indeed extradited, and why is he being prosecuted when the New York Times is not? You're on mute.
Sorry about that. Thank you, Alexander. You know, when I was presented with the idea of fair trial, I prepared a fairly legalistic response, and maybe I will go into that. But hearing the remarks just now, it reminded me of something when I was a young prosecutor. We had a couple of cases involving entry into naval bases by folks who protested the activities of the US military. And it would involve things like smearing blood on computers, things like that. And one of the defenses that was raised was justification, because the US military was doing things that were contrary to basic notions of a citizen of the United States and indeed probably mankind. These kinds of defenses were generally precluded based upon an analysis of the statute, which generally required general intent, knowledge that one was entering into a restricted facility. And I certainly don't mean to liken one case with another. I think every case is unique. But I think that there is going to be, if this case ever comes to the United States, there's going to be a big difference between the interests under the First Amendment and things that sound in justification, that crimes were being exposed in Afghanistan, crimes were being exposed in Guantanamo or Iraq. That could be a part of the defense. And hopefully there'll be time to explore that, but I don't think that necessarily is the case. I do think as a legal matter, the thing that makes this case very interesting is the main statute being alleged is Section 793, which is part of the so-called Espionage Act, but which really deals with obtaining or receiving certain items relevant to the national defense, or indeed just possessing such items and communicating them to a person not entitled to receive it. It's this latter set of charges, I think, that is the most interesting here, because what is really being alleged is that what Julian Assange did was he possessed material he wasn't entitled to, and then he posted it on the internet, specifically on Wikileaks. And that's really what this set of charges is about. And for a lot of the legal commentary that I've run across, that is the focus of why this is such a novel prosecution. Indeed, one of the earlier cases, which involves a similar situation, is a case involving a couple of employees at the, I think it's the America-Israel Public Affairs Committee, or AIPAC, who received classified information from a defense analyst, or perhaps it was a Department of Defense analyst. And they were prosecuted. These individuals at AIPAC were prosecuted for conspiring to possess this material when they should not have, when they were not entitled to it. And the judge who handled this case out of the same district where the current case is being charged, wrote a lengthy opinion and recognized this is novel, because in the earlier cases that we've seen under the statute, it's folks who are within the government who are being prosecuted. They've had the training, they've received the clearance, nevertheless, they receive or access the information and they disclose it outside the government. In this case, we have folks in AIPAC, they're not subject to any of that stuff. They don't receive training, they don't have a clearance, but they make efforts to obtain this information. And this is different, said the judge. And in order to address that, the judge went through the statute, and without going into the details of scienter and whatnot, he held that in order for this statute to stand muster against a vagueness charge and against a First Amendment, a claim that this would violate the First Amendment, he, among other things, held that the government was going to have to prove that the defendant knew the nature of the information, and knew that the person with whom he was communicating was not entitled to it, and yet the defendant went ahead. The government also had to prove that the information related to the nation's military activities and so forth, that it was closely held, and that disclosure could cause injury to the nation's security. And as a result, partly as a result of that decision, the government dismissed that prosecution. And so it would be interesting to see if this prosecution goes forward in the United States, will there be a similar ruling? Will there be additional mental state requirements placed on the government? Because as the judge recognized in this case, despite the government's claim that the First Amendment was not implicated, the judge held, well, in fact, the First Amendment is implicated. This is activity that would be covered by the First Amendment. And the real question is, based upon the Supreme Court's case law, is this the kind of activity that nevertheless must yield to the government's interest in national security? Because there is, for instance, perhaps a clear and present danger or other considerations that might apply. And I would expect that based on these kinds of cases, because this is not the only one, that there is going to be a lot of litigation and a lot of attention focused on this issue. And this is really not the only one. I only mention it because that's where the discussion has gone, and quite rightly so, because you may not have a lot of sympathy for what Julian Assange did, especially in terms of his direct contact with Chelsea Manning and others, encouraging them to obtain this information, not because it was generally of interest, but because this was information that was classified by the United States that could not be easily obtained. And therefore, he believed that there was an interest, not just by himself, but by others, in obtaining it and making it accessible to the public. Whether that's morally right or wrong, I do think that's a little bit of a different question than the one that the lawyers will have to face in the case. But I think what is a genuine issue is if you bring this case forward and it goes forward to a trial and perhaps conviction, where do you draw the line? And I think the points that were made in the Pentagon Papers matter, maybe not so much in that case itself because it involved an injunction, a prior restraint, but there were certainly prosecutions, I think, as we're all aware, that stemmed from that and that ultimately were terminated for other reasons. But nevertheless, these are, I think, the questions that were raised 50 years ago and would be presented in this case. There are some other issues as to fair trial, but I think given where we are, maybe it's best just to hold those in case there's time to discuss those.
Jen, Deborah, would you like to respond? Well, I'm going to go ahead.
I was just going to point out the Pentagon Papers in a way is even a less sympathetic case in that Daniel Ellsberg was the whistleblower who had a duty to the government to arguably, whereas in Julian Assange's case, he's a foreign journalist who didn't have any duty to anyone under any circumstances.
He's not even an American citizen.
Can you imagine if the Chinese government said that a US journalist had published an article, had published information that was leaked by a Chinese dissident that damaged national security in China? I mean, would China have jurisdiction over a US journalist in that situation? That is directly analogous. Look what we're doing here.
I think another analogy would be, what if a Russian journalist were to disclose war crimes being committed by the Russian government in Ukraine? How would we in the West view those activities? Probably positively. But I have a question for Ron, which is as follows. Ron, in 2013, the Justice Department gave a strong indication, not a legally binding one, but a strong indication that it was not going to indict Mr. Assange. That was obviously under Obama. Trump comes in and there is a change of heart and the indictment is prepared and unsealed. How political is the prosecution of Mr. Assange, and is there any likelihood that under Biden that the winds may blow back again into the non-prosecute camp?
Well, I think that's awfully hard to assess. I think what is probably likely to happen is if Mr. Assange comes back, there will be a lot of pretrial litigation. And I imagine that there will be rulings, some of which will go the government's way, some of which will go against the government. I also imagine that the defense is going to be very active in seeking certain things, seeking discovery, for instance, seeking particular witnesses. I have no idea exactly what the role of Chelsea Manning will be if there is a trial. I know that Chelsea Manning declined to testify before the grand jury and received a contempt sanction as a result of that. And ultimately that was all rendered moot when the grand jury's term ended. But in light of all of these rulings, I would imagine that the government is going to have to make an assessment as to whether or not it can prove what it's alleged. And I think that's a really big issue. And that's probably one that, I mean, we are out of town, but There's a lot alleged. Whether the government can prove these things, especially given what appears to be the prospect that Chelsea Manning is not available, I think that is going to be something that leads to an analysis by the government as to whether or not it can go forward, whether it offers something different to try to resolve the case, or some other option.
I'm very sorry, but we are almost out of time. I don't know if anybody would like to respond or add any closing remarks. If not, I would like to thank the panel very much indeed. This has been a really interesting discussion. I frankly, with hindsight, wish we'd had 2 hours rather than 1. I want to apologize profusely to all of the members of the audience who put some very interesting questions to us. Thank you for participating. I'm sorry we couldn't get around to it. Obviously, there's a huge amount of material. And I particularly want to thank Jen, who's interrupted her holiday to be with us today, or her vacation, I should say. Thank you, Pete. Thank you, Ron. Thank you, Deborah. Thank you, Writers Guild. Thank you, Beverly Hills Bar. And that's it from us. Thank you very much indeed.